You work on the water. You're a commercial fisherman, a fixed oil rig worker. You work on a cargo ship or somewhere in the harbor. You get hurt. You're doing the work traditionally done by a seaman. You are a Jones Act seaman. What is the Jones Act? Learn more by watching this video. And by the end, you're going to know all your rights and what to do if you get hurt in the course of your employment on the navigable waters, okay? Jones Act, otherwise known as the Merchant Marine Act of 1920. What is the Merchant Marine Act of 1920? So let's start from the beginning. Constitutional rights guarantee you a jury trial at common law. The Seventh Amendment gives you the right to a jury if you are injured at common law. Unfortunately, if you're injured on the water, that is not what they call common law. That is Admiralty law. That is maritime law, and that is different from common law. So if you're injured at sea, traditionally under Admiralty law, you'd only be guaranteed the right to a bench trial, which means a judge that is both the judge and the jury. And that's not always the best thing for you. So at Admiralty, you don't have a jury, but because of the Merchant Marine Act of 1920, Jones Act seamen are entitled to a jury trial for claimed personal injuries. So, what does a Jones Act seaman have for rights? Orlando & Associates has been practicing maritime law since we were open in 1980. We have in this firm what's called Proctors in Admiralty. A Proctor in Admiralty is a special designation given to an attorney who handles maritime law by the Maritime Law Association of the United States. So that means we are specialists in handling cases of people who are injured at sea or on the navigable waters. What are navigable waters, you ask? Great question. Navigable waters are waters that can take you from sovereign to sovereign. So think from country to country, from state to state. That is a navigable waterway. Usually the ocean, the Great Lakes, the Mississippi River, other rivers like it that go between states. Those are navigable waters, okay? Sometimes you could have a giant lake in the middle of a state. It's landlocked on all sides by the same state. That is not what you traditionally would call navigable. But if that lake is connected by a river to the ocean, well then, now it becomes navigable, all right? So that's a simplified way to express it, but the navigable waters has to be connecting two sovereigns, two states, a country and a state, country and another country, the high seas, etc. Those are navigable waters. But if you are injured in the course of your employment at sea or adjacent to it, you have different rights than someone who's injured on land. So let's talk about what those rights are. A Jones Act seaman has the right to bring a negligence case against their employer. Unlike if you were on land. If you're on land and you get hurt in the course of your employment, and there's no third party involved, you are generally restricted to bringing a workers' comp case for your medical bills and for your lost wages, and that's it. You cannot bring a negligence action against your own employer. But if you are hurt in the course of your employment at sea, irrespective of some third parties involved, you can bring a negligence action against your own employer. That's a very special right that's given to the Jones Act seamen in the Merchant Marine Act of 1920. You're also entitled, if you're injured at sea in the course of your employment, to maintenance and cure. Maintenance and cure is the Admiralty definition, essentially for the type of workers' comp benefit that you'd get on land. It's very similar. Maintenance, meaning payments to you while you're injured and while you're injured in service to the vessel and you're out of work and you're unable to, they pay maintenance benefits to you. Those maintenance benefits usually cover your living expenses, like rent or mortgage payments, like your utility bills, like your groceries. Those are maintenance payments. And cure is your medical payments, medical bills, and out-of-pocket expenses related to your medical care, for medication, for doctor's visits, for hospital visits, for surgeries. That's what cure pays for. And they pay while you are out of work. after you were injured in service to the vessel. So you have a negligence claim that you can bring against your employer, the vessel, the oil rig, the cargo ship, the what have you. You have the maintenance and cure benefit, and you can also bring a claim for what they call unseaworthiness. Okay, unseaworthiness does not mean that the boat can't float. The boat and its appurtenances, the things that are attached to the boat, are not working correctly. They are defective. They are poorly maintained. They have to be replaced. They are dangerous. There's a number of different things that can mean that the vessel is unseaworthy. But if those things aren't working properly and as a result you are injured, you can bring a claim under the unseaworthiness definition in Admiralty law. So Jones Act seamen have more rights, especially when they are at sea, than an injured worker would have against their employer on land. So what are some examples? The most common that we see here in our firm in Gloucester, Massachusetts and New Bedford, Massachusetts are commercial seamen, commercial fishermen. They go out on a dragger or a long liner, a scallop boat, a lobster boat, and they go out and they get injured in the course of their employment. It's very heavy work. They could be just injuring their back lifting a heavy weight like lobster crates or a scallop barrel. They could be slipping on deck and falling. There could be cutting bait or cutting fish and have an injury to their hand or what have you. There could be a sinking at sea. There could be a thousand different ways to be injured or killed at sea. It's a dangerous job, and there's no ambulances out there, and there's no trees or buildings blocking the wind, and there's no one protecting you from the weather. And even though you might be on a 100-foot boat, that's nothing compared to the power of the open ocean in the North Atlantic or in any other navigable waters. And if you are injured out there, the injuries are usually humongous. They're usually life-altering because it's such dangerous work. We have a whole memorial here in Gloucester to those who are lost at sea, who we can't even recover a body to bury in a graveyard because they can't be recovered, because at best the Coast Guard is hours away. If you are in that situation, if your family loses a loved one at sea, if you are injured at sea and you are out of work and you don't have any options, you have to pay your bills and take care of your family, you have rights. Pick up the phone and call us. We will, at a minimum, educate you on your family's rights or on your rights relative to bringing a claim for your injuries. What's the worst that can happen? You spend 15, 20 minutes, half hour on the phone, you learn your rights. You hire an attorney who's only going to charge you a contingent fee, not take any money up front, and you have already put yourself in a better situation. Don't trust insurance companies that insure vessels. Those claims are not against the owner of the vessel necessarily. They're usually against their insurance company. Those insurance companies are going to do everything in their power right away to make sure that you don't make a full recovery. Call us right away. Call us right when you hit land, and Orlando & Associates can help you. So if you want to learn more from a Proctor and Admiralty about the good, the bad, and the ugly of the personal injury industry as it applies to Admiralty law, to those who are injured on the high seas or within the 3-mile coastal limit, come back, subscribe to my channel, and you'll learn more about Admiralty law specifically and also personal injury law generally. And you'll learn more about what it means to have a Proctor and Admiralty represent you rather than just some personal injury attorney who doesn't do this every single day.